That degrades the system.
Yeah, I mean, listen, like I'm not much unlike Mr. Obernolte. I appreciate the goals of the bill. I'm just trying to get to the bottom of what's included and what's not included. So my understanding is that venting is no longer allowed with 1371, and so that is why venting is considered fugitive. Is that correct?
Venting is no longer allowed within 1371,
Okay.
and it is included within the types of gases that are counted as lost and the types of gases that are considered within the bill, which would be disallowed for receiving ratepayer recovery for.
Okay, Mr. Quirk.
So, quoting from the PG&E opposition letter, SB 1441 reaches beyond the scope of a gas corporation's jurisdiction, and so doing penalizes gas corporations for emissions outside of their control, such as extraction and production of natural gas. Now, I've looked at the bill, and I just don't see that in there.
It's on, you have to look on the last page of the bill.
Okay.
Page 5, line 20, 21, and 22.
Oh, you're right. I was just looking at the summary. Okay. That seems unfair to me.
So while everybody's looking at that section, I'll ask my question, and that is, yeah, I don't think we have an amendment in mind. It's just something I'd like you to address, perhaps as this bill moves forward, if it moves forward, and that is, the one circumstance where it does seem a little bit unjust to me is when there's a dig-in. I believe that's the right term, when someone damages the gas line by accident or by negligence. In those circumstances, yes, we want the gas companies to repair the line as quickly as possible. And we want them to have a disincentive to let it stay unrepaired. But I'm just curious about the circumstances where you could have someone damage a line. You could have, let's say, of the 100% lost, 90% is lost because of the initial incident, and then you have a patch put in place, and then 10% is lost because the lack of permanency of the solution. How do we equate for the different fairness concerns in a situation like that? I'd just like you to address that perhaps as the bill goes forward. Nothing we're going to require today, but that's something I think would make the bill better and more just. Any other questions? Mr. Quirk again.
I didn't get a response from the author. I think it's unfair for extraction and production losses to be charged to the utility. Is there a rationale for that? Because otherwise I don't feel I can support the bill.
Sure. Mr. Quirk, so the bill says that utilities should not receive from ratepayers money to cover the loss of gases that are experienced in the extraction. And when you look at what that is, the same reasoning that says utilities should not be penalized for that, the question is, if they do not own the extraction, should they be receiving money from ratepayers for gas that is lost in that extraction? They do own storage, and there are losses in the storage, as we've seen from Aliso Canyon, and they do receive ratepayer recovery from ratepayers for that purpose. And so this language was specifically designed so that the utilities don't collect money from ratepayers for operations, A, that they don't own or they don't operate, and B, that they don't recover from ratepayers that with which they have control over.
So even if they don't have control and the loss is not their fault, you're going to penalize them. Is that correct?
No, sir. They don't receive ratepayer recovery already for gas that is lost in the extraction that they don't control. This does not give them new authority to receive ratepayer funding for that.
Just asking PG&E, is there a change being made here or not?
No.
I guess I understand what the witness is saying about if you own a storage facility, and I don't know if Deanna wants to opine here. I'm not a trained lawyer, nor am I a gas expert. When you remove it from a facility, a storage facility that you own, and Deanna, interrupt me when you want to take over,
That's a cue.
I guess I'm not going to dispute, and I don't know the regulatory term for you extract it from the storage facility, but the word storage is also in the bill.
Yeah, I'm just frankly, it's just very confusing. First of all, our main priority is safety and the reliability of the system. If we have to vent the gas to make sure the system is safe and reliable, we will do that. That's part of our obligation under California Public Utilities Code 451. So there may be times that we have to, vent gas so that to maintain the safety and reliability of the system. I'm just really confused by the bill, so I can't answer. I don't.
I'm confused too. I don't think I can move forward at this time.
Mr. Chair, if I could just comment here.
Please do.
This venting issue is not a part of this bill. It's law. It was made law in 1371. So we're not rehashing that here.
We get that. We get that. I think Mr.
Well,
Quirk's
I don't know that everyone did.
Okay. I think the current question before the committee, which was asked by Mr. Quirk, has to do with line 21 on page 5, which does appear to this attorney to say that a utility will not, well, I'll phrase it another way, will be responsible for gas loss during the extraction and production process, and that's pretty clear. But I'd love for someone to speak about that.
Mr. Chairman, I think the issue there is that they're receiving, they would be, what this is prohibiting them from doing is charging their customers for gas they don't pay for. That's
specifically because they're not in the extraction business.
Yeah, they're allowed to get recovery for gas that somebody else produces that they don't actually buy. That's the issue here, I believe.
It might need some clarification because I'm not sure how the contracts work, but I don't think. Let's say there's a contract for gas that is taken out in the San Juan Basin and it's piped to Wild Goose Storage in Sacramento and it's stored. I thought the utility sought recovery for the gas from going out from the storer to the end user. I'm pretty sure that they don't seek recovery for the gas purchased on the coming from Oklahoma or whatever, but I could be wrong.
So we're just stating the obvious.
That's pretty much what they shouldn't get recovery for leakage.
No,
Dr. Quirk is pretty smart, and he says it's not obvious. I'm just trying to.
It says the Commission shall not allow gas corporations to seek or receive recovery from ratepayers for the value of natural gas lost to the atmosphere during the extraction, which they don't do. So they shouldn't get ratepayer money for it.
As I read the bill, you're making them pay for it. You're making them responsible for it, and that's certainly what the opposition has said. If you will work with the opposition to make sure that they're only responsible for their own system, I can go forward. But I don't think it's clear in the bill, and knowing how judges misinterpret what we do, I think this needs to be made clear, that they're only responsible for what they actually control.
I am in full agreement with you, and I think once we clarify this, you'll recognize that the intent of what we're doing also is what you're...
All right, with that, I'll move the bill.
Okay, thank you, and you have my guarantee.
Mr. Chair, I just want to go out on a limb and say that when you experience a horrific tragedy of San Bruno facing the most horrific damages and reputational and business issues and billion-dollar fines, your investors and your actions have every incentive to do the right thing. Thank you.
Mr. Chair, if I may.
You may. And then we're going to try to wrap this up.
I don't want to take more time with the Commission, but I just have to say, out of respect for all the Californians who have died and lost property and suffered as a result of all the unmentioned tragedies caused by a particular utility over the past years, that's just not acceptable. If San Bruno stood alone and it was unique, that'd be one thing. But it was one of many tragedies, and there needs to be change. And this is directly related to the previous bill. How could all this happen if the CPUC was really regulating them? And that's why we have to reform the CPUC so these things don't continue to happen.
Terrific. Thank you very much. If that's all right with you, I'll take that as your close. Bill has been moved by Dr. Quirk, seconded by do you have a question? Seconded by Cristina Garcia. Please call the roll.
The motion is do pass and re-refer to the Appropriations Committee. Gatto.
Aye.
Gatto, aye. Patterson.
No.
Patterson, no. Burke. Aye. Burke, aye. Chavez. No. Chavez, no. Daly. Eggman. Cristina Garcia. Aye. Cristina Garcia, aye. Eduardo Garcia. Hadley.
No.
Hadley, no. Hernandez.
Aye.
Hernandez, aye. Obernolte.
No.
Obernolte, no. Quirk.
Aye.
Quirk, aye. Santiago. Ting. Williams.
All right, we'll place that on call, and we will lift the call when we get some more members in here.
You are one of
Mr. Hill has been patiently waiting, the illustrious Mr. Hill. And you have something like 27 bills before us today.
I think we do today, Chair.
I'm doing all right.
So proud of all of them.
Thank you.
And of being here today with you.
Okay, so, first one up, let's go with 512, if
Very
that's
good.
all right with
that
you.
would be perfect. Thank you very much, Mr. Chair. And we are handing out, the sergeants are handing out some information that I will be relating to it in a little bit. First of all, I wanted to add on to Senator Leno's comments about your leadership, Mr. Chair, on this entire subject and in the past year, and especially now, and the results that we've seen are definitely because of that. So thank you. Let me first accept all of the committee proposed amendments listed in the analysis and express my deep appreciation to committee staff for their work on this bill and the two that I will present next. The amendments clarify that a local government can only seek intervenor compensation in the wake of a catastrophe caused by a PUC-regulated utility, and not by issues such as service quality or affordability, which are already handled by other intervenors. SB 512 is the first of three safety-focused bills I'll present today. The bill contains a number of uncontested provisions from my Public Utilities Commission reform bill last year, which had been vetoed in October. Among them are requirements for performance metrics for the PUC and its executive director, the clarification that the PUC administrative law judges are subject to the Administrative Adjudication Code of Ethics, and the requirement that the PUC reach out broadly to interested parties before opening a rulemaking. The contested portion of this bill is specific to safety and whether there are circumstances in which local governments should be eligible for intervenor compensation. Rather than tell you why I think this is important, I'd like to show you. The PUC has been working for years on this map that you have in front of you, and which shows the areas of the state that are susceptible to a power line ignited wildfire. So if you see the maps there, the Butte Fire and CPUC's fire hazard area. It's right here. And you can all see that. Now, the draft map came out last September. There was a draft map that came out last September as the Butte Fire raged through Calaveras and Amador counties. The map was approved earlier this month. That is this map as you see here. This is the large map. The Butte fire was caused by contact between a power line and a tree and became the 7th most destructive fire in state history, destroying 818 structures, 549 homes, and killing 2. As you can see, the Butte fire lies outside the area that the map defines as high hazard. The original proposed decision to adopt the map didn't discuss the Butte fire at all. In fact, only one party objected to the map's approval, and that was the city of Laguna Beach. Cliff Edison, chair of the Calaveras County Board of Supervisors, spoke of his experience in the Butte fire before the PUC when it met in September and in Sacramento in May. He pleaded in public comment that the county's risk be considered. Here's the question before you today. Should Calaveras County, where the Butte fire consumed more than 10% of the land area, be eligible for intervenor compensation to advocate for fire safety? Or should they be doing it on their own dime? Is the opposition's argument that the county could just raise taxes or reallocate funds convincing? In the June 16th Calaveras Enterprise article titled, quote, "County will continue to drain savings," Administrator Shirley Ryan cites how the county still hasn't received many federal reimbursements and the Butte fire's effect on property values is still unknown. We've seen what happened when the city of San Bruno participated in pipeline safety proceedings. It improved the safety for the entire state. I'm not arguing that Calaveras County should be encouraged to participate in PUC proceedings because I want them to protect their own interests. I'm arguing that we need them to participate because they are in the best position to protect all of our interests. Now, the second map overlays in blue communities that CAL FIRE has identified as at risk of wildfire. You can see that the overlap between these communities and the PUC's wildfire hazard map isn't great, especially in Northern California. If the Butte fire could happen in areas of suspected low risk, like the community of Mountain Range that was almost wiped off the map, what other communities are at risk for power line wildfire? This brings me to the second group that should be eligible to apply for intervenor compensation, consortium of local government entities participating in improved public safety. We shouldn't have to wait for disaster before addressing safety issues. Now, I hope does anyone think that we get this disparity between CAL FIRE's communities at risk and the PUC's wildfire hazard map if local governments had been involved from the beginning? This provision was modeled after Assemblymember Weber's AB 2120, which would allow consortia of schools to receive intervenor compensation that is now in the Senate, and I voted on it, I believe, last week. That bill passed this committee earlier in the year. My bill is narrower, restricting participation to safety. There are many, many barriers to participation in the PUC's arcane proceedings. This bill lowers one of those barriers because we need them all to participate. Thank you, members, for your indulgence in this.
Thank you very much. Let's go to the first witness in support. Here we go.
Karen Mills for the California Farm Bureau. Chairman and committee members, I'm here to speak on a very small part of the bill dealing with the transcripts and the public records that would be available, publicly available through commission proceedings right now. Transcripts are on a pay-as-you-need basis, and what the senator proposes in the bill is a limited provision that would require that the transcripts be made publicly available, and that's the part of the bill that we're focused on for these purposes. Thank you.
Thank you. Let's go to public comment and support.
Eddie Moreno on behalf of Sierra Club California in support.
Thank you. Witnesses in opposition, please come forward.
Mr. Chairman and members, Carolyn McIntyre on behalf of the Cable and Telecommunications Association. In opposition to only a portion of the bill, First, let me make clear that we do not object to local governments being eligible for intervenor compensation as it relates to their participation in catastrophic emergency and activities, as reflected in the bill analysis. We do, however, oppose the inclusion of a consortium of local governments. Local government's responsibility is, in fact, to police, to govern for the citizens of the community, including policing those communities for safety and to ensure that everything is to the good of their citizens. That is the purpose for which they are formed. A consortium of local governments could not only include multiple agencies in a given county, a consortium of local governments could also well include representatives from multiple counties. Would each of them be eligible for intervenor compensation? Also, let me add that intervenor compensation is paid for, as you know, by rates that are collected from ratepayers. So under the proposal, you could in fact have ratepayers from Sacramento paying for incidences caused by a particular utility in San Francisco. We don't believe that's appropriate policy. As I said, we do believe it is appropriate to have local governments participate on behalf of their communities on situations such as San Bruno and Aliso Canyon. We believe the bill is overly broad when it brings in consortiums of local government. We'd ask that the bill be amended to eliminate that provision.
Maybe I can interject just now because it sounds like there's going to be some more testimony on this. So what about that, Senator? I mean, you've got this idea that I'm trying to think of an example, but you have a city that is very clearly affected. Maybe a group of 5 cities then come together as a consortium. Should the sort of the outliers geographically or in terms of being affected, should they be eligible as well?
Well, the outliers mean those that are a part of the conversation, those who had witnessed and experienced the catastrophic event, those are the ones that should participate. I have no interest in we were working with the committee's analysis, and I think it's our goal that a consortium would operate and function more not say uniquely, but efficiently, I guess, in terms of the intervenor approach. That's what we were looking for.
So an example that I would give, and my district, I have 5 cities in my district, and I know Ms. Garcia has a dozen plus 9. Okay, so like you can imagine a situation where, let's say, God forbid, there was some sort of catastrophe near Burbank Airport, but Burbank Airport in my district is run by Burbank, Glendale, Pasadena Authority. And you could imagine a situation where the harm is limited to the city of Burbank, but then other cities jump in because they feel like they have an interest.
Well, I mean, I think you have to show that you have an interest in this. I mean, it's not something that you would want a consortium to be you have to have the loss. And if you don't have a loss, if you don't have the interest is because of the catastrophe, it is because of the event. And here, in this case, you may have, because of Long Beach and the surrounding cities, that could have had some devastating effect economically and others because of it. So I think it would be important to and what I did not mention it before the opposition began, but as you know, we've been in working with you and your staff. And with the governor's office, we've been trying to focus on getting this particular segment, as others, to a point where it can be limited enough to deal with what specifically we want to cover. And that conversation will be ongoing. And I know that that's understanding of the opposition, that it's our goal to make this as restrictive as possible, to identify those specific needs and that's really what we're trying to do. And if we're not there, and I don't think we are because there is still opposition, I think that we'll get to a point where they will be comfortable with this and there would be no opposition.
Terrific. I trust you on that. Thank you. Let's go to the next witnesses in opposition, but all I'd ask you to do is please don't repeat. Thank you.
Mr. Chairman, members of the committee, Bill Devine with AT&T. We have been working with the author and we're working with the committee. So we're encouraged that there's an opportunity for further improvement with the bill. Our immediate and specific concern is the fact that there are currently over 500 cities that operate in the state of California, all of which have facilities in the ground that have potential problems in the future. You never know when, you never know where. We don't want to create an intervener compensation system that invites virtually everyone to participate in virtually every proceeding and or set up law firms and others that go on retainer and make it a habit of intervening in cases because they will be compensated. So that we want to see some limitations. The Senator just spoke to that issue, and I think that's very important. There's one other thing that I would observe here for the committee as well. The focus of all of this conversation is about PUC reform. And as the Senator referred a moment ago in his testimony, the Commission was well aware of some of these concerns and well aware of some of the local government input. And for whatever set of reasons, it did not get factored into their final decision. So it seems to me the focus should be on PUC practices and policies as opposed to adding an additional input on intervener comp, because some localities did in fact testify, did in fact engage in the process, and today all local government is free to participate in the Public Utilities Commission processes. They just don't receive intervener compensation when they do. So we want to work with the author. We want to work with the committee. We like the idea of limiting and narrowing the definition, so we appreciate that. And with that, we'll continue to try to make a constructive contribution. Thank you very much.
Thank you very much. Next witness.
Martin Mattis for California Water Association. CWA is concerned about SB 512 shifting the funding for activities of local governments from tax revenue to utility customer rates, and especially concerned about the consortium becoming a perennial participant in PUC proceedings at ratepayers' expense. I appreciate Senator Hill's indication that you have to have the loss in order to be a participant. We did see that in the reference to the local government participation, but we didn't see that in the description of the consortium's participation. So if that can be nailed down with respect to the consortium, that would deal with that aspect of the problem, so that the consortium would be an ad hoc entity and not one that would be there all the time making a career out of intervener compensation. CWA also recognizes the tremendous financial burden that a few local governments, such as the City of San Bruno, have borne to participate actively in PUC proceedings arising out of tragic events that have stricken their communities. And similar burdens have affected governments affected by wildfires involving major electric and telecom utilities. These are cases where affected local communities are relatively small, and the utilities that are involved have large ratepayer bodies who, whether for good or for bad, can bear the expense of supporting the involvement of the local governmental entities. In the water industry, it's a lot different. The water utilities are smaller by a couple of orders of magnitude in comparison to the large energy and telecom utilities. And their ratepayer bodies are in relatively compact communities where the community may be just as financially capable as the utility is.
Sure.
And so
and I don't mean to cut
we
short,
believe that it'd be appropriate to set a limit on this kind of a program of, say, a utility with at least $1 billion of revenue.
Got it. Okay, next witness.
Mr. Chair and members, Steve Carlson for CTIA, the Wireless Industry Trade Association. We echo the comments of our colleagues. One of the things we would like to point out is that we've seen expanding the intervener compensation from that which it was originally designed to do, which is to allow those without a voice to have a voice. In this case, we would submit that cities do have the ability to raise revenue. They are represented by various, lobbying groups and lobbyists themselves, including legal staff. So we have a concern about that. Certainly we'd like to see the bill narrowed. We are also concerned that as the wireless industry, we are certainly not the cause of any of these things to happen. However, it's quite likely if there is a catastrophe that affects our facilities, we will be drawn into the proceeding. involuntarily, but even involuntarily, you have to defend yourself and act. And in that case, we would certainly be responsible then. Our companies would, and ratepayers would, not ratepayers, our customers, we're not ratepayers, would be responsible for intervener compensation. So we do have a real concern about making sure this is narrowed to just focus on what the problem is. I know Senator Hill wants to do that. We've been dealing with him on other issues, which we'll hear about in a few minutes, in terms of trying to narrow a very legitimate concern to one that doesn't necessarily bring in those that aren't the focus or should be the focus.
Thank you. Okay, public comment in opposition.
Pam Loomis on behalf of Consolidated Communications. We're only opposed to the intervener comp expansion part of the bill, and we're just worried about the precedent and the slippery slope of who's next at the IC trough.
Mr. Chair and members, Rod Brewer for Southern California Edison. We have an opposed unless amended based on the intervener compensation provision in the bill. We do see the intervener comp piece as a double tax, but also to the part about the local government entities. Based on the 2012 census data, there are 4,400 local government agencies. That includes cities, counties, special districts, school districts. So when we look at the bigger scope of what a local government entity is, it covers all of that in the umbrella. So we do respectfully oppose the bill unless that provision is removed.
Yolanda Benson on behalf of Calcom, the small rural telephone companies, and I echo exactly what has already been said in opposition of that amendment.
Thank you for echoing. All right, questions from the committee. Mr. Quirk.
So, Senator Hill, in looking at the committee's amendments to narrow somewhat your bill, starting at the bottom of page 3 and going to the top of page 4, in particular, it says cities can do this after suffering a catastrophic material loss. And that makes a lot of sense to me. That's San Bruno, that's Aliso Canyon. Those are extraordinary events. It's when we get to a consortium of local governments, and it says through prevention of material loss, and you particularly mentioned the Butte Fire, which is actually outside of an area, as you pointed out, that would ordinarily have this type of loss. That would seem to open it up to consortia throughout the state and would mean that every community basically could but intervene and get costs, and that's just too wide for me. If it stopped at the people who've had a catastrophic loss, I could see something there, but to go to prevention of material loss as a matter of safety, every entity in the state, I think, could be intervening. That's my concern.
No, and I accept that, and that's what we'll be working on, to look at with the committee to see if we can, here again, narrow that down to something that would
all right,
be specific to what we're talking about.
And then I noticed that the people who are up here at the table are not although we did hear opposition from some of the power utilities in general, these are just utilities that I would ordinarily think not to be involved. Why are they part of the bill?
Well, you would think not. However, when communications wires come loose and blow across electric lines, they cause fires. That's what happened in 2007 when a Cox Communications lashing wire came loose, was blown across an SDG&E power line and caused the Gujito fire.
All right.
So
all
it
right.
does happen.
Okay.
And then when utility poles are overloaded with communications equipment, and I'm sure some of them have added to that weight, they can topple and cause fires. That's what happened in 2007 to the Malibu fire, which was caused by 3 top-heavy utility poles loaded with both electric and communication facilities. They fell during a high windstorm.
You've made your point on that one, but I still think the bill is just too broad.
On the
type of
yeah,
when you talk about
and that's
safety.
We've all agreed to come together and resolve that issue. I agree, and it was interesting. Edison is coming up or speaking in opposition to the bill, but the bill that I mentioned, Assemblymember Weber's, that added intervenor compensation for schools, they didn't oppose that bill. So why they're opposing this? And also, if I may respond to the comment related to local governments, cities can raise taxes to do this, or they can reprioritize. They have to go through Prop 26, as we know, to raise taxes or to get the money that would be necessary. School districts, they could get the money as well. They could have a parcel tax and raise money in a similar way. I just wanted to respond, if I could, and this could be my close, if depending on the question.
Oh, wait, I
know, but I just, if I could respond. But go ahead. Go ahead.
No, just as long as the language is as broad as this, I don't feel I can support the bill. I just wanted to say that to you. Thank you.
Okay, let's just be clear that we have a commitment from Senator Hill, who does not break his commitments, that he's going to work to narrow the ambiguity in the consortium language. That's very important, I think, to this committee.
All right. Having said that, I will move the bill.
Okay, thank you. And maybe this will obviate some of the other questions. Mr. Hill still has a number of bills before us today. Do we still have these questions? Absolutely, sir. Okay,
just briefly, with the narrowing of what entities can intervene to those that are materially affected because of a disaster, I could support that.
Thank you.
So I'll second the bill.
Mr. Hadley.
And I'll be very quick. I don't try to wordsmith in committee very often, but echoing this concern, if on the top of page 4 of the committee analysis, if item number 2 is a consortium of local government entities, each of which qualifies under one, that is a route that I would be supportive of.
Okay, that makes good sense. Thank you.
Okay, so I think that's the committee's will from what I'm hearing. It seems like we can come to some sort of arrangement and get some language.
I think so too.
Mr. Vice Chair has another question.
So as I understand it, the commitment here is to narrow so that the local consortium has the same kind of jurisdiction after suffering a catastrophic material loss.
Correct.
Good. That's good.
That's mine.
One other. There was a point about, for example, cable companies and other will have wire, and so they ought to be jointly responsible if the utility pole is overburdened. Look. It was a utility company that put them up there. And there are not a lot of alternatives in rural areas and the like. So it seems to me pointing a finger at a cable company that is getting permission from the utility to use its pole really is the utility company's issue. So that broadness, I think, ought to be narrowed as well. Thank you.
Thank you. Sure.
Why don't you close now? And,
thank you very much, Mr. Chair. I would.
Sure. Okay, I'm sorry. Mr. Hernandez.
I just wanted to say thank you for working with the opposition. It's become clear to me that the opposition is continuing to work with you on this issue, that they're committed to do that. Earlier today, before I knew that you were accepting the amendments, I had communicated that I couldn't support if you were doing something with the intervener compensation. The amendments address that. And I'm pleased to know that you're committed to continuing to work to narrow. I understand the issue of having many small municipalities involved and wanting to come together in a consortium model. I represent about 12 cities myself, and many times when these kinds of issues arise, they do impact more than one municipality. So I see the need for it, and I appreciate your willingness to work and your flexibility in the process. So I think the bill should be moving forward to continue this important dialogue.
Terrific. Thank you very much.
Thank you, Mr. Chair. Thank you, Mr. Hernandez. And I did want to, in my state one thing. The only reason that San Bruno, in fact, the only reason I believe that we are seeing the tremendous reform that the chair and others have been working on and coming about is because San Bruno, the city of San Bruno, after that explosion 5.5 years ago, received $70 million from PG&E as a kind of like here's a check for what we did to your community, and they used that money, hundreds of thousands of dollars of that money, in order to gain the access that was necessary for information, in order to have the attorneys that they could intervene as much as possible in these activities and the proceedings at the PUC. Because of that, I believe is because we're here today, and without that, they could not have done that and would not have. So I respectfully ask for an aye vote, members, and thank you for the conversation and discussion, and thank you to the opposition for your willingness to continue this and get to the right place.
Thank you all. Bill has been moved by Quirk, seconded by Hernandez. Madam Secretary, please call the roll.
The motion is do pass as amended in the committee analysis and refer to the Appropriations Committee. Gatto?
Aye.
Gatto, aye. Patterson? Not voting. Patterson, not voting. Burke? Chavez? Not voting. Chavez, not voting. Daly? No. Daly, no. Eggman? Cristina Garcia? Eduardo Garcia? Hadley? Aye. Hadley, aye. Roger Hernandez?
Aye. Thank you.
Obernolte? No. Obernolte, no. Quirk?
Aye.
Quirk, aye. Santiago? Ting? Williams?
Okay, that bill will place on call. And just everybody, it's now pushing 4 o'clock. We could do this one of two ways. We could take a 3-hour dinner break now. Anybody? No? Nobody wants to do that. All right. So we should try to move a little bit more quickly through the balance of our schedule here. We still have about, 10 bills to go or so. So I'll ask. Oh, bring in pizza, says Mr. Quirk.